Hello, and thanks for joining us. This is some important follow-up to your estate planning or your elder law planning at Unreturner Burke and Freeze. Hi, I'm attorney Dave Freeze. I'm chairman of the Trust, Estates, and Wealth Preservation section of Unreturner Burke and Freeze, and I work with a great team of people. You may have worked with me, or with my partner Doug Kahn, or with some of the members of our team, including associate attorneys or paralegals. I'd like to begin whatever you did by saying thank you for one, being a client of the firm, and two, for taking the time to view this video, and finally, for reviewing your estate planning and your next steps. This video is important. It doesn't take very long, and it's going to be very helpful. I'd like to also congratulate you. You made a great decision to do your estate planning or to do elder law planning. Very few people actually ever do it, and those who do often don't take the time to do it right. But you've done both. And the savings of time and money for your heirs may be substantial. In any case, you also know that your wishes are now documented and clear so that they can be carried out by the people who you've picked to carry them out. So let's review what you've received in this package and what you need to do next. First, you should have received copies of documents and/or an estate planning binder. This binder would contain an entire set of the photocopies of all of your documents. If you didn't get them in a binder, you've probably gotten them in a cover that indicates that they're copies. The photocopies will ordinarily include copies of your will and a revocable trust if you have one, a durable power of attorney for someone to handle your finances if you become incapacitated, a medical power of attorney so that one or more people you've selected can make medical decisions for you in the event that you no longer can, a living will. A living will often indicate to your decision makers what you would and would not want in the case that there is going to be no recovery or where death is imminent. You'd also probably signed a release form by you telling us when to release your power of attorney. And you've probably also signed a HIPAA authorization so that you could speak to your so that we could speak to your treating physician to determine if you're ever incapacitated and when we should give that power of attorney out. You may also have other documents depending on your particular planning, such as elder law trusts, which are designed to protect assets from a nursing home, or irrevocable trusts designed to remove life insurance from your estate or to protect other assets. And finally, you might have life insurance from federal or estate tax from creditors. So you might have documents designed to do that. Note, if you do not currently have these documents, you can always decide to add them to your estate planning at a later time. Just call us. You can call us at 610-933-8069 if you ever need these additional documents, or if you ever have questions about your planning. We're here to answer them. Please review the documents to make sure they're all there. If they're not, again, just give us a call. These binders or copies are just for your records and can be kept at home for your reference at any time. They are not the originals and they don't need to be protected. They do not need, for example, to be stored in a safe deposit box or a fireproof vault. Now, you also will have received your original documents if you requested them. In some cases, you might have asked us to keep them, but if you've requested them, your package should contain the originals of the documents that you requested. Clients will often request to receive and to keep the originals of their wills, and when you've requested them, your revocable or irrevocable trusts. You may also have requested the originals of your medical powers of attorney, living wills, and in some cases, even your financial power of attorney. We should have provided you all the originals you requested in this package. Let's review these documents one by one and what you should do with them, with the originals. So, first let's start with wills and trusts. If you have a will or a will and a revocable trust, your originals of those documents should be placed in a fireproof vault or in a safe deposit box. People often worry that if these documents are stored in the safe deposit box, that they will not be able to retrieve them or their heirs will not be able to retrieve them. However, banks are required, upon your death, to allow the executor under your will to enter the box and obtain the original of your will. It's important, therefore, to let the executor know where the will is stored, how to access it, and where additional information is kept. Storing your will in a safe and fireproof location is a great idea, as a lost will, or one that has been accidentally destroyed, is presumed to have been revoked. So be sure they're in a safe and fireproof location and that the executor knows how to get them. Medical power of attorneys and living wills. If you have a medical power of attorney and or a living will, they should be kept at home so that they can be used in the event of an emergency. Most clients do not give their living wills to the hospital or doctor. Rather, when they're asked if they have one, they tell the hospital or physician that they do and that a family member will provide it if it's ever needed. For that reason, many people keep these originals at home. Of course, you're welcome to discuss them with your doctor at any time and to provide a copy if you wish. It's also quite appropriate for you to make photocopies of these documents, or we may have provided more than one to you for delivery to your spouse, children, grandchildren, or others who are responsible for your medical decision making. You also probably have a financial power of attorney. This is a durable power of attorney, and it allows an agent to make financial decisions for you when you're incapacitated. These decisions include the ability typically to file tax returns, handling your banking investments, paying your bills. Most people don't keep the original of this document at home. Rather, they leave the original or multiple originals of that document with us. If a doctor later confirms that you're incapacitated, or if you tell us to, we'll release it. Again, it's important to let your agent under the power of attorney know where the power of attorney is kept or how it should be obtained from us. You'll also have given us instructions on the release of the power of attorney. You've probably provided us with a letter of instruction telling us to release your durable power of attorney to whomever you've nominated, 1, in the event you tell us to, or 2, in the event a physician confirms, pursuant to your instructions, that you're incapacitated. So that we could talk to the physician, you've also provided us with a HIPAA authorization, allowing us to have that discussion. Memorandum and or letter of instruction. You may have also prepared a memorandum or informal letter of instruction to your executor, trustee, or family members. If you'd like us to keep a copy or duplicate original, please provide one to us, and we'll enclose it in your file. Remember to let us know if you update it. In any case, you should be sure to enclose that memorandum of instruction or a letter to the executor with your original will or documents so that people see it. Most often, clients prepare informal or non-binding letters of instruction. These could be as simple as something handwritten letting the executors know which personal items go to which beneficiaries, or else they could be more complicated and give executors and trustees even more information that you'd like them to have. Now, this is important. Please be sure to review your beneficiary designations. We spend a lot of time going over these in the course of your planning, both at your first appointment and then subsequent appointments. Remember, your will or trust may not work properly and as you intended unless you follow the planning instructions that you've been given about who owns the property and who is designated the beneficiary of assets, such as life insurance, annuities, investment, bank, and other retirement assets. And unless you're careful to follow the instructions, there may be negative income tax consequences as well. Now, this part requires work, and it might seem hard, but it's really very vital. Most lawyers that do wills don't even discuss this, either because they don't understand its importance or they find it complicated and difficult to explain to clients. So they just avoid it. But you can't just skip this step. Why? Well, for a couple reasons. We know that without the right beneficiary designations, your plan might not work properly, and or your heirs could owe a substantial amount of income tax they might otherwise be able to avoid or at least to delay. For those reasons, your attorney at Unreturn or Burkett Freeze has reviewed with you the importance of having the right beneficiary designations. He or she has also reminded you of the vital importance of designating the correct beneficiaries of IRAs, 401ks, and other retirement assets and annuities. So you need to be sure to review them and to confirm that they are correct. To help you, we've also prepared a report, as well as your personalized instructions that you received during the planning process. That report is included with your documents and your estate planning binder, but you can review it here at this URL. You can also call to have it mailed to you or emailed to you. We're happy to do it. The office number again is 610-933-8069. Let's review. To quickly review, your original will and trust, if you have one, should be placed in a fireproof storage or in a safe deposit box, and the executor and or the trustees should be told where they are and how to obtain these documents in the event of your death. Your durable power of attorney has probably been kept with us and will be released only when you tell us to or a doctor says you're incapacitated. If you've kept an original, Consider not releasing it to the agent until the time is right to pass on this level of control. While you can always revoke a power of attorney, it's best to release it only when you want the agent to begin to act. Your original medical power of attorney and living will are probably in your possession, and photocopies can be delivered to whoever is making your medical decisions, so they already have it in the event of an emergency. It's also important, following our meeting, to verify that all of your assets are titled properly, as we discussed, and that the proper beneficiaries are being used. If you have any questions, be sure to contact the firm and the lawyer or paralegal who are helping you with your estate planning. We suggest you update your estate planning every 3 to 5 years, or sooner if you receive an inheritance, or when there are changes because your children are grown or have new needs, or when there are marriages or divorces, or when there's a death or a birth in the family. It's been an honor and a privilege to serve you, and we look forward to continuing to do so in the future. If you have any questions, please contact us. As a thank you, we've also enclosed a gift certificate in your packet that you could use for yourself or to share with others for a substantial discount on estate planning services. The amount and value of that gift certificate depends on what level of estate planning and service you've requested. All our VIP, executive, and concierge clients receive a gift certificate each year that they can share with their family. So if you're interested in that, please let us know. Please also be sure to give the gift certificate that we've given you to a child, grandchild, friend, family member, or someone else who needs it to do their estate planning. Or you can keep it and use it for your own purposes at your next visit. We'll also be contacting you approximately 3 to 4 times a year with a notice of changes in Pennsylvania federal tax law and other important estate planning matters. We do that with email and also by sending you a newsletter that contains these. Please remember not to opt out of the email messages. Stay on the list. You'll also be receiving a newsletter containing updates mailed several times during each year. Finally, we'll also be sending you reminders at various times over the next few years, reminding you that in the event of a death or birth in the family, divorce, you receive an inheritance, you change life insurance carriers and or reduce or increase life insurance, or if there are other substantial changes in your personal or financial planning, that these may also impact your estate planning, and it's important to let us know. There's no charge to call and to ask us. Thank you again for your time, your courtesy, and your consideration. Please call 610-933-8069 with any questions you might have.